Partnership law. It would be difficult to conceive of a complex society that did not operate its businesses through organizations. We're going to start with talking about partnership law. And when we talk about partnership law, that term, to me, makes me think of simply just partnerships. But in a legal education perspective, when we talk about partnership law, that also encapsulates limited partnerships and limited liability companies because of their similarities too, and how some of their attributes have sprung forth from partnership law. Why is it important to understand partnership law and what governs it? It's hard to imagine a business or an enterprise. Well, if you're in a business with another person in a quest to make money, you are going to be in a partnership. Therefore, it makes sense to understand partnership law and your other options in order to protect yourself liability-wise and to take some tax advantages. Thinking about this from a legal theorist perspective, a business is separate from the individuals that actually run the business. The business has a name, so the business, therefore, is some type of entity, and the amount of rights or the powers or the ability to sue or for that entity to bind itself in contracts, all those different types of things have had more or less powers throughout the years. And I would say currently, businesses, as far as having these separate entity forms, is likely at the strongest that it's been in this point of time. So you've picked this separate entity. Is that important for taxation? Yes, it sure is important for taxation. You can be taxed a number of different ways. Now, if you take the generic partnership, which is going to be the unincorporated form of business or a unprotected form of business or an informal, in a legal speaking, form of business, income that the partnership makes is going to pass through that partnership, pass through that entity, straight onto those personal individual tax returns. So as you're distributed equal to your share of the partnership, so if you're in a 50-50 partnership and you're getting 50% of that income, that is going to flow straight through, and those dollar values are going to be straight on your tax return. Partnership law is largely influenced by two particular acts, one the Uniform Partnership Act, the other being the Revised Uniform Partnership Act, the UPA and the RUPA. The UPA and the RUPA, the sections and the theories and the legal rules in those texts have been largely assumed by the states. States might prefer one more than another or prefer some sort of mixture and have enacted those laws and rules inside of their state statutes. And because of that, partnerships can own real estate. Creation of an express partnership. All right, we're now thinking about how do we create a partnership. Very, very easy. You can create a partnership on accident. To have a partnership, forming a partnership can be done in a number of ways. We're going to talk about the express partnership first, and that is the partnership where you say, yes, I would like to be in a partnership, and the other person says, yes, I would too. And this can be an oral agreement. It can be a written agreement. It doesn't have to be written, but of course, partnerships are quite complex, so you writing down how your partnership is going to work would be a fantastic idea, but an express partnership doesn't need to be written down. It can be done orally. Why is this important? You might be thinking back to contract law. And in contract law, we know there's a thing called the statute of frauds. Statute of frauds is a funny term, which means, does something need to be in writing? And so we're wondering, does this partnership need to be in writing? And no, it does not. Underneath a statute of frauds, your partnership does not need to be in writing. And this can be a bit of a trick question here. Why doesn't it need to be in writing? Because under the statute of frauds, if it takes longer than a year to accomplish something, well, that thing is supposed to be in writing. Well, because a partnership can be ended at any point in time, because of that, even though it may last longer than a year, the fact that it could end at any moment in time means that it does not need to be in writing. And I'm going to scroll right past that page there. Remember, if you want to look at anything in particular for longer than I'm speaking about it, just pause it and take a gander, take a read. Creation of an implied partnership. An implied partnership exists when, in fact, there are two or more persons carrying on a business as co-owners for profit. What does that mean? Co-owners means you need more than one person, so we're talking two people. Two people need to carry on a business for profit. You can do this quite for accident. Hey, Bob, how you doing over there? I'm doing great, Dan. Hey, Bob, would you like to go paint that house and split however much money we make painting it? Oh, that sounds great. Let's go do that. All right, let's go, Bob. Suddenly, Bob and I formed a partnership. That's fine and dandy until Bob does something dumb and causes some sort of accident, spills paint on someone's property or something like that, and then suddenly I'm being sued for Bob's mistake. Creation of partnership by estoppel. We've come into estoppel many times now in this class. Estoppel is where the court finds some sort of injustice and creates a thing in order to protect individuals that have relied upon something. So you have contracts by estoppel. Here we have partnerships by estoppel. So there's going to be reliance. There's going to be some individuals who perhaps held themselves out as if they were doing a business, or perhaps it just looked like they were doing a business. I've got to pause this here, hopefully. So there has to be a representation to a third party that there is in fact a partnership, and then reliance by the third party on the representation. The textbook had an example where there's two people. They're at a lumber yard. These two people always seem to be hanging out at the lumber yard. They seem to be making decisions together like they're in a business together, and then the salesperson, in speaking with them, seems to acknowledge the fact that the lumberyard salesperson seems to think that the one person is the financing guy, the money guy of the partnership, and the other guy is more the hands-on guy in this sort of like some kind of building or contracting partnership these two guys have, and they never say, hey, we're not actually partners, and the salesman has detrimental reliance that the one guy is the financer and will be paying the bills and not the other guy that seems to be the more handy guy. Limited partnership. A limited partnership is defined as a partnership formed by two or more persons, so that would be one limited partner and one regular partner. You don't need to have two general partners in a limited partnership. It just requires two persons. One would have to be limited, and what this does is it creates a form of protection for the limited partner. The limited partner can only make limited impact upon the firm and the decisions of the, I'm sorry, I said firm there, but the decisions of the business. And the general partner is the one who is managing and running the business, the limited partner being more of the money guy, and the other partner being more of the one who's managing the business. The general partner is going to have all the same liability that you would have under a partnership, which is unlimited liability. A general partner in a limited partnership and a partner in a regular partnership has unlimited liability, meaning they can attack the partnership assets and any personal assets of the partner. The only person with any protection is a limited partner. Their assets will be protected. Their own personal assets will be protected. Limited partners are putting money into the business and then they want this protection, but what can they do? The law provides some safe harbors, meaning some safe things they can do, some rules of thumb that are okay. A limited partner can act as an agent or employee, blah, 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 these items here that it's listed. They can consult with the general partner of the firm. They can request or attend meetings of partners, and they can be a surety of the firm, meaning they are the ones on the line for a loan. Limited liability company, even better for protection. Everybody gets protection. All the members do. A member being the fancy word used for partners inside of a limited liability company. We don't typically say partners. What we say is members in the legal realm. Limited liability company is going to have 6 characteristics listed there. The ones that are important to us in regards to the difference between partnership and a limited liability company, one is going to be limited liability. You, as the member, your personal assets will be protected, and any type of remedy someone seeks in the legal court will, against legal court, any remedy awarded to them, they can seek it against the business assets only and not the personal assets. Limited liability company, their operating agreement may provide for either a member-managed LLC or a manager-managed centralized LLC, meaning that you can have different forms of management inside the limited liability company. We were kind of talking about that before with the limited partnership, where there's the limited partner that doesn't make much managing decisions, and then the managing partner or general partner that makes all the managing decisions. Limited liability companies, some of the great things about a limited liability company is it affords this high level of protection but a low amount of formalities compared to some other forms of corporate protection like the S corporation or the C corporation. What's some of the differences, you might ask? Well, an LLC, a limited liability company, ignores some of the corporate formalities such as minutes and annual meetings, but it still needs to abide by other formalities, and if they don't abide by those formalities, then the corporate shield may be broken or the corporation might be defective from the get-go. How does money come into the LLC and then go to the members? How does that work? Well, that is going to be provided by the operating agreement, kind of like your partnership agreement. You would decide, hey, we're 50-50 partners. I get 50, you get 50. An LLC can do it all different ways, just like a partnership can. You get 50-50, 35-65, whatever it is. You can make that up as far as who is making what amount of money, and it flows through the business. The business is not taxed at all. The income flows right through the business straight onto the members' tax return, just like in the partnership example. Liability, we discussed that. Dissolution. Dissolution is the fancy term to say how a business is dissolving, is wrapping up, is ending, is expiring, terminated, etc. There are some different events that can occur where an LLC would dissolve, listed there. Some questions. Let's get into some nitty-gritty things here. Here we go. Remaining partners have a right to continue a partnership after dissolution. What do you think? And the answer is going to be yes. A partnership is informal. It is the most informal means to carry out a business. One partner decides to stop, the other partner can continue on with the business even after it has been wound up. And a limited partner typically has, we talked about this, they're going to have limited liability. Their maximum liability will be equal to the investment they put into the limited partnership. So if they put $50,000 into the business, that's what they can lose. They're not risking the money they've got in their own personal bank account, etc. As to the management of a partnership, unless agreed otherwise, all partners have equal right to manage the partnership. This is in a basic general partnership. I'm not talking about a limited partnership here. I'm talking about a regular old partnership. Now remember, it's very easy to accidentally become a partnership when you say, hey, my friend Bobby, let's go paint this house together and split the profits. Boom, suddenly we have a partnership. Well, Bobby has equal management, so Bobby can go ahead and book us for another house painting for a different house. Maybe I didn't want to paint it, or maybe Bobby decides to give the owner of the house a discount, and I'm not super happy about that. That type of thing. If 2 or more persons want to start a business as co-owners for profit, they will most likely form a partnership. Partners must have access to all books and records and may be allowed to make copies of these records. That's correct. A general partner has unlimited personal liability for the debts of the limited partnership. Whoa, you're throwing a lot of terms at me there. We got a general partner, unlimited personal liability for debts of a limited partnership. What do you think? This would be true. A limited partnership provides protection only for the limited partner. Any of the general partners are going to have the unlimited personal liability. The general partners are the managers. Basically, they're the same as the regular partner in a partnership. The only difference between a general partnership, the basic partnership, and a limited partnership is a limited partnership happens to have at least one person who is the limited partner, the money person, who's shoving money into the business but staying out of the management role. They're essentially just an investor. In a limited partnership, general partners typically have what? They have unlimited personal liability for the debts of the limited partnership. Remember, general partners, no protection. A limited partnership is an agreement between at least how many people? And at least how many general partners and at least how many limited partners? This seems a little bit tricky. What is it going to be? It is 1 and 1. One general partner, one limited partner. You need two people at a minimum to be a limited partnership. One of them needs to be the general partner running the business, and the other one is the money person in the background, simply an investor, the limited partner. Joint and several liability means that the partners must be sued jointly. Incorrect. That's wrong. You can sue any of the partners you want. For some reason, if there's 5 partners and you only want to sue 3, sure, go ahead. I think most people would sue all 5, but you never know the reasons that they have. You may sue any number of the partners if you're suing a partnership. Partners have duties to one another, including, if I do share a duty to other partners only, a duty of obedience only, a duty of care only, it would be the 3 of them. Unless agreed otherwise in the Articles of Partnership, which of the following are the rights partners have in regards to their interactions with other partners? This is a great one. The first one is right. The right to share in management only. That's correct. The right to share in profits only. That one was correct too. You can manage. You can share profit. That's what you're going to do as partners. The right to compensation you do not have. I have a pretty good example of this. I used to renovate houses, and I don't know, like my 3rd or 4th house that I bought, renovated that sucker. It took me a large number of hours to renovate, and I made money on it, but at the end of the day, I probably made less than minimum wage at the time. I would have been much better off spending my time at any other job, earning minimum wage, rather than working on this house. What does that have to do with the right of compensation? Well, you're in business. Guess what? In business, you might not make money. You might lose money. That's why you don't have the right to compensation in a business. A business is and can be a risky venture, and so you don't have the right to compensation, but you do, yes, have the right to split profits if there are any. So in my house example, if I had partners in that house, we wouldn't all have the right to making at least a minimum wage, because that would have been impossible. As I said, I spent a lot of time working on that house, and I made less than minimum wage if you want to break it up into an hourly salary. Hey, guys. I was kind of scared. I don't remember where I was. I'm going to pass on by. Whoa. Apparently going to spin us around here. Where are we at? Okay. Which of the following represents a partner's interest in the partnership? A combination of the share of profits and a return of capital contributed by the partner. Profits only. Contributed things only. Wages are due to the partner only. A partner has no interest in a partnership. The 4th one there, wages that are due. Remember, you're not due any wages. There's no right to compensation. The right that you have is your share of the profits and a return of any capital contributed. So if I'm entering into a partnership, let's say to paint houses, and I put in $500 to buy some nice paintbrushes and a ladder, that kind of stuff, pretty minimal, but I'm just starting off in this painting business, and then we paint one house and decide, me and my partner, we're like, well, that was fun, but I'm going to go do something else because I really have decided painting houses is not what I love. So I would have a right to split the profits that we made, hopefully, off of the painting of the first house, and then I would have a right to the return of my capital. The basic law of partnership is currently found in statutory law. This is a great trick question because we started off talking about the Uniform Partnership Act and the Revised Uniform Partnership Act, the UPA and the RUPA, but these are secondary sources. They don't actually bind anyone, but the states have gone ahead and taken those on and enacted those as their own legislation. And when states are enacting laws, they enact what type of laws? If you would say statutes, you would be correct. It would be statutory law. So because of that, this answer is true, even though we talk often about the UPA and the RUPA are telling these different things about how partnerships and limited liability companies work, and you think, well, those are secondary resources. They are, but the states have enacted using the UPA and the RUPA for guidance. So yes, statutory law. An oral agreement to form a partnership is valid. That's true. Remember, because a partnership can end at any time, you can do it orally. Most partnerships have no fixed terms and thus are not subject to the statute of frauds. Let's think about this one. It can be a little bit tricky. We just came off the other one where we answered true, that partnerships can be oral. Now we get into this one, and it's like, wow, no fixed term, not subject to statute of limitations. What the heck is it? Or statute of frauds. What the heck is this talking about? It's just a different way to say, again, that partnerships can be oral. Partnerships have no fixed terms, correct? They can be ended at any point in time. That's what no fixed term means. We can end it, cancel it, terminate at any point in time. No fixed term, and are thus not subject to the statute of frauds. Statute of frauds is just a fancy way to say a thing doesn't need to be in writing to legally bind some parties. So, yeah, it doesn't have to be in writing. So that's what this is saying. So this is true. Most partnerships have no fixed terms and thus don't need to be written down. Partnerships cannot be formed by two partnerships. That's false. Partnerships can be formed by all different kinds of entities, including multiple partnerships. A partnership may be formed by estoppel. We talked about that. That's true. One of the advantages of the LLC form over the sub-S form is what? Well, that is less formalities such as no minutes and no annual meeting. An LLC is created under and regulated by federal law. Totally a trick question. We were just talking about how partnerships, we're talking about partnership law, we're talking about LLC, limited liability companies as well. Those are regulated by state law, state statutory law. All right, well done. If you made it to the end, give yourselves a partnership law high five, and I will see you on the other side. Professor Crane signing out. Have a good morning, a good afternoon, good night, whatever time it is, wherever you are. It's coming up on May the 4th, so May the 4th be with you.